You're watching The Legal Breakdown. Glenn, we've got an update here as far as Donald Trump's ongoing prosecutions are concerned with regard to Jack Smith. I'm looking at an NBC News headline right now. Special counsel Jack Smith seeks pause in Trump's election interference criminal trial. Now, in our previous episodes, we've spoken about the fact that Jack Smith can dismiss the cases against Donald Trump, and that would preclude the DOJ from ever bringing them up again in the future. Or Jack Smith can opt to do nothing, let Donald Trump corruptly have his DOJ withdraw from these prosecutions against him. And that would at least give the opportunity for a future DOJ to resurrect these cases against him. So I'm looking at this headline here, and it says that Jack Smith is seeking a pause in Trump's election interference criminal trial. Does that mean that Jack Smith is poised to dismiss these cases against Trump?
Not necessarily, because even though the reporting is characterizing this new Jack Smith court filing as a pause, what he actually asked Judge Chutkan to do is vacate current deadlines. Okay. What does that mean? Well, remember that Judge Chutkan was in the process of litigating the presidential immunity claim to see whether the 4 criminal charges that Donald Trump is indicted on for trying to steal the 2020 presidential election were all official presidential acts, therefore he shouldn't be prosecuted for any of them, or whether none of them were official presidential acts and he should be prosecuted for all of them, which would be the right answer under the law. So with all of these deadlines set, in light of the election's results, all Jack Smith did was file a very short 1-paragraph motion saying, Judge Chutkan, we're asking you to vacate those deadlines. In other words, cancel them, but don't otherwise do anything in the case while we, special counsel, our team, the Department of Justice, decides how and if we can move forward in this case. That is all he has asked Judge Chutkan to do. So that doesn't really tip Jack Smith's hand one way or another as to whether he will, on his own, move to dismiss the cases, because the Department of Justice policy, the Office of Legal Counsel, the OLC memo says he can't prosecute a sitting criminal president. That is a policy that needs to be revisited in light of our present circumstances. Or if he will say, you know what, I am not dismissing. In essence, I'm going to buck the policy or test the policy. I would say there is this thing called exception to policy that I think he ought to be considering right now. And then let Donald Trump's corrupt attorney general, whomever he appoints, I assume it will be somebody at least as corrupt as Bill Barr, let them throw the cases out in an exercise of corruption, if not lawlessness. But as of right now, I don't think this 1-paragraph court filing gives us any more information about which of those 2 options Jack Smith may exercise.
And just for posterity, for those who didn't watch our previous episode on this subject, allowing Donald Trump's DOJ to corruptly dismiss this case unto themselves, that would effectively preserve this issue for a potential future DOJ to resurrect it, because any effort for Trump, the defendant, to have his own appointed attorney general to dismiss a prosecution against him could be construed as corrupt, correct?
It could be, and you have definitely earned your law school degree over the last several years that we've been doing these daily legal breakdown videos. And let me just put a finer point on it. Basically, there is something called the Statute of Limitations, which is like a deadline. And for whatever reason, the law provides, and these are statutes that can be changed, mind you, the law provides that if a federal prosecution does not commence within 5 years of the date of the crime, then it can never be brought. The statute of limitations has expired, and prosecutors are prohibited from bringing a prosecution once it is more than 5 years old. However, if the reason the case wasn't brought or didn't sort of go to fruition with a trial was because of crime or corruption by the defendant, Donald Trump, ordering the dismissal of cases, then at least that preserves the argument, the ability of the prosecutors to say, well, guess what? We may be at the 6-year mark, but the only reason we had to wait this long was because of Donald Trump's corruption. So there would at least be an argument to make. Now, if it bubbled all the way up to the Supreme Court, I could hazard a guess as to what the Supreme Court may say. But in my opinion, Brian, it's far better to have Donald Trump get rid of his own cases as a product of corruption than Jack Smith say, you know what, out of the goodness of my heart, okay, that's a bit of a joke, in recognition of this horrific policy that says we shouldn't be in the business of prosecuting a sitting criminal president, I'm just going to go ahead and dismiss Donald Trump's cases. I hope that is not the choice Jack Smith makes.
That lends itself to my next question, which is Jack Smith prosecuted war crimes at The Hague. This guy is no pushover. He understands the difference between right and wrong. Like, he is out there to take down the bad guys. And knowing what he knows about Trump's criminality in this case, why would he confer this benefit of the doubt? Why would he confer this goodwill onto Trump by dismissing the case and precluding the ability of a future DOJ to bring up this case again by allowing them to themselves corruptly dismiss it?
You know, Brian, it's a great point. I don't want to say desperate times call for desperate measures, but I think desperate times, potentially democracy-ending times, calls for pushing the envelope as far as it can possibly be pushed. But, you know, prosecutors generally feel constrained by Department of Justice policy unless they can find a way to get an exception to that policy. And I think there's a parallel point that could be made. Whereas the Supreme Court bestowed presidential immunity on Donald Trump, telling him, you can commit all of the crimes you want against the American people to try to steal a presidential election, and you can't be prosecuted for those crimes. So Joe Biden has that same power. So think about it. He can commit all the crimes he wants. He can do whatever he wants to exercise his core constitutional powers to save the democracy from an avowed day one dictator without ever being prosecuted.
So why doesn't Joe Biden come forward and say you know, as part of my presidential full sweeping executive authority, I demand that the OLC memo be cast aside? The OLC memo saying that a sitting president can't be indicted. And this way they have to continue, at least until Jack Smith is fired by Trump, they have to continue in prosecuting him.
I can't answer that question.
In theory, he could do that, though, correct?
In theory, he could do that. He could override a DOJ policy memo for sure. And the problem is, he will probably say, I am not willing to engage in overreach or something that could be viewed as misconduct or something that could be criticized as so extremely political that I'm unwilling to do it. And unfortunately, he would be unwilling to do it at the expense of American democracy. And that's the piece, Brian. Look, I'm an old gutter kid from Jersey, and I'm going to fight up to and including with my last breath for the rule of law, for accountability, and for democracy. And I'll take my lumps. Do I want to violate the law if the Supreme Court gave me the authority to violate the law with immunity? No, I would not be wild about doing that. It cuts against my very core. Would I use the powers granted by the Supreme Court to try to save the democracy from an avowed day one dictator in every way I could bring myself to do it? I would, and then I'd take my lumps. But I think we're going to go quietly. The institutions of government are going to go quietly and are going to hand our democracy over to an avowed day one dictator who said he would terminate the Constitution and use the military against the Democrats. I don't know why we're willing to just hand it over under those circumstances.
One more question on this, and that is that OLC guidance says that you can't indict a sitting president, but it doesn't mandate that if there's some ongoing prosecution that you have to dismiss it. So why is it inherent here that Jack Smith has to dismiss this case as part of the OLC memo? Why does he have to do anything? Why can't he just hands off and allow Trump's his predecessor, once he gets fired, to just corruptly dismiss it, again, preserving the ability for the DOJ to prosecute Trump in the future? Why does he have to dismiss this?
Yeah, that's a great point. If we care about the text of the policy, he could certainly urge Judge Chutkan not to dismiss, but to pause, to simply say, listen, We will put this case on ice. It will remain in existence. The statute of limitations will pause, but we will not dismiss it outright. And I think he would be wise to make that request, because if Judge Chutkan refuses to grant that request, that at least will be another fact that goes in the plus column when it's time to try to revive this case, if it ever comes to that once Donald Trump leaves office. So you're exactly right. Let's not go quietly into the dictatorship. Let's fight with everything we've got.
Yeah. Well, we will, of course, stay on top of whatever Jack Smith decides to do next. Again, the options here are for him to dismiss this case, thereby precluding us from ever being able to resurrect it in the future, or just doing nothing, allowing Trump's DOJ to corruptly dismiss this case and thereby preserve the ability for a future DOJ to possibly bring this case back up. So we will, of course, stay on top of what happens next. For those who are watching right now, if you want to follow along, please make sure to subscribe. That's the best way to support our work. I'm Brian Tyler Cohen.
And I'm Glenn Kirshner.
You're watching The Legal Breakdown.